All right. Good morning. Thank you so much for joining us. Let's go ahead and get started with today's Wednesday webinar. Today, we are going to be discussing Social Security disability for multiple sclerosis. And here's our roadmap for today. We're going to start out, talk a little bit about some Social Security disability basics, move into some guidance from the agency regarding multiple sclerosis or MS claims, talk about listing 11.09, move into additional considerations, and then finally, how an attorney may be able to help you with your disability claim. A little bit about me. My name is Caitlin Wildoner. I'm the founding attorney of Beacon Disability PLLC, which is a law firm based in Florida, where we exclusively practice federal administrative law, assisting clients with their Social Security disability and supplemental security income cases from the initial application stage through the appeals council. We can help most people outside of the state of Florida. If you have a situation that for some reason we can't help with, either inside or outside of the state, we do try to connect you with somebody who can. So I don't take questions on the live webinar. And then on the replays, I don't take questions, specific questions in the comments. And the reason for that is because the answers depend too often, and they depend on specific facts. And so without asking too much personal information, getting into those details, I just say I don't take any questions. If you have questions, though, we will drop a link in the chat on the live right now. And then on the replay, the link will be down below where you can schedule a call at a time convenient to you. You can schedule a call with us and we can talk through what questions you have, see if it's something that we can help with, or if it's just answering simple questions for you. You don't know which way to go. We are happy to do that. I do enjoy answering questions. I can't do it well enough on the live webinar and then through comments on the replay. So I don't. The other thing that we will do, in addition to the link, which has been dropped in the chat, we'll do it again at the end. The other thing that I do is at the very end, the last slide shows our contact information. And so you can also give us a call or send us an email directly if after watching the webinar you do have questions. Sometimes we can fit you in a little earlier than what my calendar link may allow for. It just depends on what the schedule looks like. So in any event, that's who I am. And like I said, today we're going to be discussing Social Security disability as it relates to multiple sclerosis or MS. Here is a little bit about Social Security disability basics. There are two different Social Security disability programs. There's Social Security Disability Insurance, or SSDI benefits, and then there's Supplemental Security Income, or SSI benefits. As you can see, both programs require that you be disabled and unable to work for a period of at least 12 months due to mental and or physical impairments. So that's the same. Now, you don't have to be disabled for full 12 months before applying, but if you apply a couple months into the disability and being unable to work, what Social Security is going to be looking at is, does it look like you will remain disabled for at least a year? So Social Security disability is not temporary in that they don't pay benefits for a period of less than a year. Where the programs differ is SSDI, you have to have sufficient work credits. We typically say you have to have worked 5 of the last 10 years. SSDI benefits, when you're paying into Social Security through your paychecks, that goes into kind of a pot for Social Security benefits. Out of that pot will come future retirement benefits and any potential Social Security disability insurance benefits. So SSDI benefits have a work history requirement, and the ultimate benefit amount depends on what you were able to pay in while you were able to work. So that's SSDI. With supplemental security income, it doesn't have the work history requirement, but instead it requires that you have limited income and assets. So if you are single, you have to have less than $2,000 in assets. If you are married, you have to have less than $3,000 in assets. That threshold does not include one house and one car, but it does include most anything beyond that. Income and asset restrictions, Social Security does have a pretty good pamphlet on that. If you're kind of close to that, They have a good information set on that. You can also call Social Security directly, tell them you want to apply for SSI, and then they can go. That's one of the very first things that they will do is make sure that you do qualify from that financial perspective. Same with when you apply for SSDI, one of the first things they do is check to make sure you have that work history. If you don't have enough work history for SSDI and or you have too many income and assets for SSI, then you'll get a pretty quick denial, pretty much right away, within a couple of weeks, that says you don't qualify because with SSDI, you don't have enough work credits. With SSI, you have too much income or too many assets. Okay, here's the Social Security disability process. There are 5 stages. We handle the first 4. So the initial application, the case is handled by your state agency or disability determination services. In some states, I think they're called the Division of Disability Determinations. So DDS, DDD, it's all the same. They follow the federal Social Security rules, but they work for your state. And that's pretty much exactly what the letter says when you get your initial or reconsideration, approval, or denial, is that somebody reviewed your case, they work for your state, but they applied the Social Security rules. At reconsideration stage, again, it's handled by the state agency. So if you get initial denial, you file an appeal, and you are at the reconsideration stage. If you get a reconsideration denial, then you'll file an appeal and you will go to the hearing stage. At the hearing stage, that is handled by people employed by Social Security, and the case is handled either by your local hearing office or another hearing office somewhere in the country. And whether it is local or elsewhere can sometimes be determined by your choice of hearing. They started doing telephonic hearings, March of 2020. We're almost exactly 3 years since they started doing those. Those have worked quite well. They started doing online video hearings, which is where you are at home. The judge is either at home or in the hearing office, and you're both appearing by video through Microsoft Teams. They started doing those probably about a year and a half, 2 years ago. Those have also been working well. And then the long-standing types of hearings are in person or a VTC, which is video teleconference. It's a little confusing. A VTC is not done at home. A VTC is done in your local hearing office with a judge who's not in your local hearing office. So it's by video, but you and the judge are in 2 different places. And then in person, of course, you and the judge are both in person in the same room. After the hearing, if you get an approval, that's fabulous. If you get a denial, then you can go to the appeals council, and that case is handled in Falls Church, Virginia. There's not really any, you don't go to Falls Church in person. It's all kind of the way it was done at initial and reconsideration, where it's all done by paper and medical records, the actual Social Security file. And at the appeals council, it gets a little confusing. What the agency is looking for is, did the judge make errors of fact or of law that, had the judge not made those errors, might have resulted in a different decision for you? If the judge made errors, but they are negligible or they wouldn't have resulted in a favorable decision, they may not overturn it. But if the decisions were material to the finding of disability, and had those mistakes not been made, a different finding may have resulted. That is what the appeals council is looking for. If the appeals council declines to review the case, then it goes up to federal court. And again, unfortunately, we do not handle federal court cases. So here is how the 5-step evaluation process works. As I mentioned before, when we were talking about the 2 different programs, the very first thing, before even this 5-step evaluation process, that Social Security is looking at is, do you qualify from the non-medical perspective? So SSDI, do you have enough work credits? SSI, are you below the income and asset thresholds? As long as you meet that prong for whichever program you apply for, or both, if you applied for both, it goes to the next step. And this 5-step evaluation process is kind of the medical portion. And so what they're looking at first is, are you engaging in substantial gainful activity? Substantial gainful activity is if you are working more than 20 hours a week or earning more than $1,470 a month in gross earnings. So if you are engaging in substantial gainful activity, either you're working too many hours or you're earning too much money, you cannot be found disabled according to their rules. The Social Security Administration will send, again, a pretty quick denial. It's not as quick necessarily as the other denial if you don't meet the other prong, but it's pretty quick. If you're engaging in substantial gainful activity, they don't really get into the medical. If you are not engaging in substantial gainful activity, the agency will go to step 2 and they will look to see, do you have any severe medically determinable impairments? They do this by looking at the medical records. So what you are saying on the application and what you say in any paperwork that they send you is relevant, but where they're trying to determine these severe impairments comes from the medical records. So medical records are critical. If you do not have any severe impairments, according to Social Security, based on the medical records, they will deny the case at step 2, say you don't have any severe impairments. So by our definition, you cannot be found disabled. If you have at least one severe medically determinable impairment, the agency moves to step 3 to look at, do you meet or equal a listing? If you meet or equal one of the listings in the Blue Book, we'll talk about the MS listing in just a minute, but if you meet or equal one of the listings in the Blue Book, the analysis stops there and you'll get an approval. If you don't meet or equal a listing, then what happens is the agency takes a look at the medical records, and they create a residual functional capacity for you. And that is supposed to be what the agency believes you are capable of doing based on your physical and mental limitations. They then take that RFC, the residual functional capacity, and move to step 4. And they look to see, okay, based on this RFC, can an individual with these limitations go back to do your past work? So that's what they're looking at step 4, is can you go back to your past work? If you can go back to your past work, the agency stops the analysis there, they deny it. If you cannot go back to your past work based on the RFC, it goes to step 5. And again, using that RFC, the agency is looking to see, can you engage in any other work? Okay, so those are the 5 steps. If you can engage in other work, again, the agency will find you not to be disabled. If there is no other work you can do, including your past work, that's when you can get a favorable decision. So that's the 5-step evaluation process that the agency will follow with every case, every adult case. Okay, certain considerations. The agency does acknowledge and understand that there are several forms of MS, ranging from mildly aggressive to highly aggressive. And the way that the agency kind of separates those is some of the more mild forms involve exacerbations and remissions, whereas some of the more aggressive forms have a steady progression of signs and symptoms with few or maybe even no remissions. So they do understand that there's a gamut, basically, of MS, ranging from mildly aggressive all the way to highly aggressive. Sometimes you've got remission periods, sometimes you don't. All of that is relevant. All of that does come in through your testimony, both in the written responses that you provide, as well as your medical records. So that is important that they understand, what type of MS you have. One of the kind of the problems that I notice with these types of cases, with cases like MS, where it's a well-known condition, and not necessarily common, but many people have, a neighbor's sister's cousin or somebody that they do actually know that has MS. And because there's that gamut from mildly aggressive to highly aggressive, sometimes the adjudicator themselves doesn't realize that the person that they know with MS has a mild aggressive situation, whereas you're sitting here with a highly aggressive situation. And so they're looking through it with kind of tinted glasses. And so that's important to note, and to make sure that we're not assuming that the adjudicator knows or understands anything, but that we're explaining, and the medical records reflect what your specific and unique situation is. Okay. When MS is listed on an application for disability benefits, the agency is going to look at your individual and your specific situation. They're going to look for whether you've got any spasms, incoordination, imbalance, tremors, fatigue, muscle weakness, dizziness, tingling, numbness. They're going to look at how well you can stand up from a seated position, how well you can walk, how well you can balance, and how well you can perform fine and gross motor movements. So if you have limitations with any of those, make sure your doctor is making a notation of that in your file, and make sure that when you are submitting paperwork to the agency that you are touching upon those specific issues. Of course, Social Security does consider other impairments that can be secondary to MS, such as fatigue, vision loss, difficulty sleeping, difficulty concentrating, difficulty with remembering things, mood swings, and depression. So all of that comes in. If you've got an open case, these are some of the things that you may want to be thinking about when you're filling out the paperwork in response to Social Security. Same with when if you've got a hearing coming up, thinking about some of these things. These are what the agency is looking at. If you have patient portal access for your medical records, or if you have your medical records and you're reviewing them, make sure that they reflect what you and your doctor are talking about. And if you do have some of these limitations, make sure that your doctor is noting that these limitations do exist. Whether they have seen them can be also helpful. For example, if you've got a difficult time standing up, or if you need a cane, or if you use the sides of a chair to stand up from a seated position, and the doctor is seeing that and they can put that in the records, that can be helpful as well. So looking to listing 1109A. 1109A touches upon multiple sclerosis, and it's going to require a disorganization of motor function in two extremities, resulting in an extreme limitation in the ability to stand up from a seated position, to balance while standing or walking, or to use the upper extremities. And so, as I mentioned, the ability to stand up from a seated position, sure, you can say that's a limitation that you have in your paperwork. But if your doctor is witnessing it, if you're sitting down and you have a hard time getting up from the chair to the exam table, and same with back from the exam table to the chair, if he or she can notate that in the records, that's helpful because it's another person, a doctor, looking at that and saying, yes, this is happening. Disorganization of motor function means the interference with the ability to move in two extremities, either your upper or lower extremity. It can be an upper and a lower. It could be both upper, it could be both lower. It does also include your fingers, your wrists, your hands, your arms, and your shoulders. Okay. An extreme limitation is the inability to stand from a seated position, the inability to maintain balance in a standing position and while walking, and the inability to use your upper extremities to independently initiate, sustain, and complete work-related activities. The second listing for multiple sclerosis is 1109B, and it's going to require a marked limitation in your physical functioning, as well as a marked limitation in one of the following areas of mental functioning. And those are the ability to understand, remember, or apply information, the ability to interact with others, the ability to concentrate, persist, or maintain pace, and the ability to adapt or manage yourself. You may have a marked limitation in your physical and or mental functioning if your MS causes persistent or intermittent symptoms that affect your ability to independently initiate, sustain, and complete work-related activities. So that's the definition of marked limitation. Here are additional considerations. As I have said, medical records are paramount. Sometimes it may seem that going to the doctor is futile, but it is helpful not only from a personal health perspective, but also from a disability perspective, because it allows the agency to see a medical professional giving their opinion on what limitations you have as a result of the MS. Remember also, the issue in Social Security cases is not just can you go back to your past work, but are there any jobs that exist in the national economy that you can do with your limitations and your RFC? If you are 50 or older, the grid rules might apply. We have done videos, maybe even a webinar before on those grid rules. So if you are over 50 and you have questions, check those videos out. They can be helpful. Functional capacity can also be relevant. That's the RFC, basically. If you don't meet one of those listings, your RFC is relevant. And again, objective medical records are important. So any type of testing that your doctors can do, opinion evidence in medical records is helpful, but objective is critical. All right, finally, how can an attorney help you? So there's a lot of things that we can do. This is not an exhaustive list, but this is just kind of the most common stuff that comes up over and over again. And so some of the things that we are able to do is we are able to provide guidance on what correspondence from Social Security actually means. We can file necessary appeals, particularly if you are already a client of ours and you get a denial letter, or if you get that denial letter and you give us a call within a couple of days, gives us enough lead time to get that appeal filed for you. We can review your medical records and case file. In doing that, we can discuss what additional records might be helpful to your specific case. Sometimes it's not possible to get those additional records. Sometimes it is. And so that's why sometimes we do have that conversation with you. We can also review your documents for accuracy and completeness. We can discuss what Social Security is looking for in their requested forms. We work with you to provide relevant updates to Social Security throughout your claim and then back. If we hear from the agency, we try to let you know what's going on. And then same with if you've got updates, we let them know what's going on. So that way, if they need to request updated medical records, they are able to do so before making a decision. If you're at the hearing stage, we prepare you for your hearing before an administrative law judge. And we also, I always put we question you and any witnesses, and that's true. We do question you. If you are an adult, there's almost always a vocational witness present, so that we do question that. As far as personal witnesses, if you're a client of ours, we tend to have this conversation before the hearing, and we will. If you are a client of ours and you have questions about your own personal witnesses, bring it up. And if we haven't discussed it yet, we certainly will. So again, that's not an exhaustive list of what we do. It's just kind of some of the most common things that we do on a day-to-day basis. And then as promised, here is our contact information. We will go ahead and drop the link to schedule a call again in the chat on the live. If you would like to call us directly, email us directly, that's perfectly fine as well. On the replay, we'll go ahead and put that link to schedule a call down below. Thank you so much for watching today, and I hope you have a wonderful day.